Welcome to Family Matters. I'm Justice Harvey Brownstone. Today, we're going to be exploring the newest and most exciting development in the way that many family law disputes are being resolved. It's called collaborative law, and it's luring thousands of lawyers and their clients away from the court system. Why? What is collaborative law? And why are so many people flocking to collaborative lawyers? How do you know if collaborative law is right for you? Well, today we'll get the answers to those questions from two highly respected collaborative family law lawyers from Victoria, British Columbia. Let's meet our guests. First, we have a gentleman who's been a lawyer for 40 years. He's also a mediator and an educator. Please welcome Mr. Robert Klassen.
Your Honor. Thank you for being here.
And joining him, a lawyer with 36 years' experience. She's also a mediator, arbitrator, and parent coordinator. Please welcome Ms. Trudy Brown. Thank you so much for being here. Well, Trudy and Bob, thank you so much for agreeing to be here. You're both very busy lawyers, and it's my great pleasure to welcome you here to Family Matters. I don't think it's any accident that one of the very first episodes that we chose to focus on was collaborative law. And there are no two better lawyers to talk about it than you. Bob, you've been a sole practitioner for a very, very long time.
I have been, and I practiced in Toronto as well as here. And
exclusively in family law?
Exclusively in family law. 10 years in Toronto and 30 here.
As a sole practitioner, working on your own?
Well, I was in partnership for about 5 years at the beginning, but I tried to use four-way meetings as a way of resolving disputes in Toronto, and at that time it was quite a strong litigation-minded environment. So when I came out here in 1980, that idea I brought with me, but it developed, and over time, of course, the collaborative process appeared on the scene, which has been a great revolution for all of us.
And Trudy, you're in a firm with 3 other lawyers.
That's correct.
All family law.
That's right.
And you've concentrated most of your career, if not all of it, on family law as well.
I did start out as a Crown Counsel. So I started
prosecuting in criminal court.
Prosecuting in criminal court, prosecuting in those days what were called juvenile delinquents, and doing a bunch of family work in provincial court. I found I wasn't a very good criminal defense lawyer when I went into private practice, so I concentrated on family.
Very different skill set, I would take it.
Very different.
Tell me, what kind of cases do you both deal with? Do you deal with moms, dads, money, custody?
Yes, most of the cases that we get kind of touch on 4 different areas. Usually when there are children involved, you have a parenting arrangement to work out, child support, there could be claims for support for a spouse, and the division of assets and liabilities. So those are sort of the 4 areas that we touch upon.
You as well, Trudy?
Yes, and I do a fair amount of surrogacy work. So when people are trying to have a family using some kind of gestational surrogate, I get involved in drafting contracts. I do some adoption work. So almost anything that involves making a family or breaking a family.
Now there's a very good mix of skills here today. Trudy, you are a collaborative lawyer and you also litigate.
That's correct.
And Bob, you used to litigate and then made a decision to stop and to only do collaborative law.
That's true.
That leads to the question, which is, I'm sure, on everyone's mind watching this telecast. What is collaborative law? What is it exactly?
Well, if I could describe it in a way, Trudy, I'm sure we'll elaborate. It's an idea of having a process whereby the 2 people, the 2 spouses, will say, control what happens. The lawyers are like guides. Each person has a lawyer usually. And what those lawyers do is try and help those people come to a decision that works best for their family.
Doesn't every family law lawyer do that though, Trudy? I mean, what's the difference?
We try. The real difference here is that we sign a contract right at the beginning of the collaborative process where both the lawyers and the client sign a contract saying they will not go to court.
Under any circumstances?
Under any circumstances, but, of course there's always a but when it comes to legal contracts, if they go to court, they have to get new lawyers.
So these are people that agree right at the outset, before they've resolved any issues, that they will not litigate.
they're choosing an option that we hope will work the best for their family. And when we're giving them initial advice, we identify what the other options are. I know when I have a client coming in, I go through the other options, such as court, such as mediation, such as the collaborative process, so that they really understand what the differences are. And I give them information that they can think about.
But this is, for a judge who spends every day in court dealing only with people who litigate, I think it's important to understand, why would anyone agree at the outset not to litigate? What's wrong with litigating?
Well, we don't want to be disrespectful of the court system, but litigation doesn't work. It effectively is the worst way to resolve a dispute.
You must have read my book.
I
I
did.
did.
Yes, of course we read your book.
Absolutely.
And
No, I couldn't disagree more, although I don't think that we will ever close the family court system. There's so many people who really have to litigate.
yeah, and litigation is important. But for those people who can stay away from that system, I mean, the litigation system is very good for lawyers. We make much more money on having a client who wants to litigate through the whole system than we do having a client who wants to resolve their difficulties.
Well, we are going to be doing an episode with two lawyers talking about how to maximize the benefit of having a lawyer. And certainly litigation will come into it. But I don't understand why two people who have just broken up and don't like each other, and I think that's fair to say, most couples who break up are not on the best of terms. If they were, they might not need lawyers at all and they would work it out, maybe. Why would they, with still not knowing how they're going to work out all their issues, take litigation off the table if maybe they might need it?
Well, I think one of the things you have to understand, and you know it well, that when people are going through a separation or divorce, they're at a very low optimum level. There's a lot of fear, a lot of anxiety, a lot of concern, anger,
feelings
bitterness,
of betrayal,
absolutely,
pain.
All those. And when you have children involved as well, any decisions they make could have major implications. If they go to court and spend $50,000 to $100,000, what does that do in terms of taking away resources for those children? And so what we try and do is explain to them that the litigation process, as Trudy says, is not the best place to be. That what we will do is help them come up with an agreement that they can both have an input into. We have a team of health professionals. This is a multidisciplinary process. We have people called coaches who can deal with those emotional problems that people often have. Let's say one person betrays another and they come into this process feeling very angry and very resentful. Well, we have mental health professionals that can help you deal with some of those issues and focus when you're coming into these four-way meetings that we usually use for this type of process.
Well, it sounds like a very holistic kind of approach to transitioning yourself from an ex-partner to a co-parent. Trudy, is there special training involved in becoming a collaborative lawyer?
There is, but can I take you one step back,
Sure.
Ms. Brownstone, and there's a pragmatic view to this as well. Because one of the things that happens when you wander into a courtroom, your entire life is public.
Yes.
Collaborative law allows you to keep your life private. You're not a reported case that your neighbors can view on the internet. And I think that's an important thing that we talk to our clients about. But the holistic approach is really important. How do we as lawyers learn to work outside the litigation system, which is where we were trained? It takes a lot of training. And Bob and I were part of the first training here in Victoria, where we went through a process of learning to trust our fellow lawyers. Now, that's an interesting process.
Was that hard?
It was.
But didn't you know each other? I mean, I would have thought in a small town, the lawyers would know each other and have worked with each other on different files before and developed those feelings of trust, or maybe not, for reasons having to do with the history between you.
Well, quite often we develop feelings of non-trust if you've worked long enough with someone. But what was interesting is we focused on how everybody perceives things. So
who gives this training?
Well, we've had a number of trainings. In fact, we brought in people from Alberta, Janice Pritchard and her Palliser group. We've done in-house training. We're always working on training. We had a lady from Australia last summer. We're always trying to enhance
And what was she? Is she a lawyer or a mental health professional?
No, she was actually a family therapist, and it was very helpful for her to work with us so we would understand better the kind of questions to ask our clients when they come to see us. We need to add to our skill base as well.
Does any law school that you know of deal with collaborative law at all? I certainly don't remember getting any of this in law school.
Well, I can tell you that the University of Victoria Law School will get at least one class on it this year because I'm teaching it. So there will be at least a mention, but there won't be training. The training's really a different way of trying to work together, because what we do is when you work for a client in a collaborative file, you also work for the other lawyer and the other opposing party.
Wait a minute. You're representing a client. So let's say a husband or a wife comes to you to act for them in resolving all the disputes that need to be resolved after a breakup. You're acting also, you have a responsibility to the other side as well?
That's right. We have an absolute duty in the collaborative process to actually make sure that there's complete disclosure and that everybody knows exactly what's going on.
I think it's part of that trust, the building of trust that happens with this process. The two parties may not trust each other at all. They may have so much negative feelings about each other. We try and help in that direction, but also the lawyers themselves have to be able to rely on each other. And one of the parts of this participation agreement are very strict provisions on confidentiality. The privacy issue that Trudy was mentioning, that's very important. I try and describe it when people come in and we have our first four-way meeting that it's not 2 and 2, it's a team of 4. And while I have a duty to my client and the other lawyer has a duty to his or her client, we are trying to work together to help that family restructure in a positive way. That's really our main purpose.
And so all of this happens outside court. All of it happens in meetings? Is that how it works?
Mostly four-way meetings, but we also bring in our other people, our financial advisors. How many times do people go through a lot of strain in terms of financial issues? We can bring in a financial advisor. A business that might need to be valued, we have a business valuator. So we have a whole team that we can bring in to assist these people without spending all that money that they otherwise put into a court system where they have no control over the result. A judge, with all due respect, makes a decision and they have to live with it. And what happens normally when you make a decision in court and problems result subsequently, guess where they normally go back to? The court system. In our process, in the collaborative process, if there is a problem, we usually resolve it back into the collaborative process. We actually have a provision in our agreement that says you will come back into the process to work it out.
And you both like this form of helping people, using your skills, using the law as a tool to help people resolve their issues more than what you used to do before collaborative law came around about a decade ago?
Well, I don't want anyone to think that I don't like going to court, because litigation is still an interest of mine, and I do both still. But what's important to know is that you can be really innovative in collaborative law. You can work outside the box, so to speak. So where you as a judge have only certain things you can do when a couple comes before you.
That's right. I'm bound by the law. I have to apply the law.
That's right.
So if it was child support, I have to apply the guidelines.
We can do something completely different. We can agree for the benefit of that particular family to do something that you couldn't possibly do.
Well, when we come back, we will be talking about how long does this take, how much does it cost, and a whole lot more. Stay with us. We're here talking with Trudy Brown and Bob Klassen, who are collaborative lawyers in Victoria, British Columbia. When we left off, we were talking about the creative aspect of being a collaborative lawyer, the holistic aspect of helping people get their lives back together in a way that's non-confrontational. Is that a fair way to put it? What makes it so creative for you? I mean, doesn't every lawyer try to solve their clients' problems as best as they can?
I wish that were so. I think that often when lawyers especially do a lot of litigation, they're very process-oriented, positional-based. How do we get a result? How do we win? How do we go in front of a judge and make sure that our client's case wins the day? Whereas in a collaborative setting, the creative side comes out. You can be quite flexible in the kind of solutions. You don't have to think narrowly. You can be very, very creative. I know Trudy and I have had a number of cases where we've been able to bring our respective creative resources to bear, and we've come up with some really interesting legal solutions that have really won the day and have transformed our clients.
I had a case, for example, Judge Brownstone, where the husband's father bought the wife a house to live in. Now, you couldn't do that in a courtroom. No one could do that in a courtroom.
I don't know if I could get my own father-in-law to buy me a house.
But it resolved the issue very well.
Yes.
And it means you can try all of those kinds of things that actually make it work for the family. Because one of the things we try and say is really, we're not splitting up a family, we are rearranging a family.
Well, let me ask you the question that I think a lot of people watching this, particularly if they are contemplating a separation or going through one right now, how do you know if this is right for you? Let's say that a client comes in, makes an appointment with you. What do you want to know about the circumstances of the relationship or the breakup that will help you decide in your own mind whether this is right? Or is collaborative law right for everyone?
No.
No, it isn't.
Not right for everyone. All right. So the big question is, how do you decide? Or how would a person watching this show know whether this is right for them? Because it sounds great.
You're going to take that, Bob, or do you want me to take
Well,
us?
I'll start out. I think, like every situation, it's a path, it's a journey, it's an education. And so when a client comes in to me, I will make sure that they know all the various options, what that looks like, what it might be in terms of time, cost, and so forth.
But what do you want to know from them?
What I want to know
when
from
you're
them,
when you're trying to guide them about which option, because you don't litigate. So if they've come to you, you've already decided that's not something you'll do. So how do you decide whether you're the right lawyer for them if you're a collaborative lawyer?
Well, what I do, though, is I try and find out what their goals are, what their concerns are. I try and identify, listen, I do mostly listening. The first interview is mostly just listening to hear what's really important for them. What do they really want to achieve in terms of the change that's going on, the transition that they're going through? And then when they have done that and I get a sense of where they're coming from, then I will tell them what the options are. And I have materials that I give them, and I give them a chance to think about it. So they don't have to make a decision right on the spot. I say, think about this. This is the option that might work for you. Maybe mediation might be more appropriate. And in some instances, court has to occur. So I will refer them out to somebody who does, that I have confidence in, who will go and litigate. But I make sure that they understand all the consequences of that choice.
So Trudy, assume you get a client, perhaps a mother comes in to see you. She wants to resolve parenting issues. The parties can't agree on when the children are going to be with each parent. They haven't been able to resolve any financial issues. She's not too clear what assets her ex-partner has, not too clear on how to deal with a division of matrimonial property, support. What do you want to know in order to help her decide whether collaborative law would be the right way to go, where you take court off the table?
Right. There's several things that I want to know. I want to know, is there a severe power imbalance between that client and their spouse? Because I think that's significant.
And how do you know that? Are you talking about domestic violence?
No, not necessarily domestic violence. It's whether one person can make decisions on their own. Lots of people have fallen into a pattern in their marriage where they don't make decisions. Well, if you're going to do collaborative law, you're making decisions about your future. And if that person's not ready to make those kinds of decisions, collaborative law is not going to work very well for them unless they get some coaching first.
So if the marriage wasn't a real partnership, in your view, and one person was making all the decisions and the other one was fairly passive, is that a sign that perhaps collaborative law is not a good option for them?
Perhaps, but I think
Perhaps.
there's still the step that we can do by sending them to coaches to see how that's going to work.
To become more assertive?
Yes, become more assertive and have more sense of what they want themselves.
Is there anything else?
To enable them to focus on the issues that they're going to have to deal with.
And what if, all right, so let's assume that the person says, no, in our relationship, like in many relationships, I did some things, she or he did other things. It was a pretty typical relationship, some give and take. Then what?
That's a good start.
That's a good start.
Then I want to know from them a little bit about their spouse, and I want to hear, I like Bob, like to listen. Personality disorders are going to create some real difficulties. So if there's a sense that one of the parties has a serious personality disorder,
How do you know?
you don't know, you guess. A lot of this is
Judges
just
don't get this training, really.
No.
We get some training from mental health professionals at judges' conferences, but I certainly wouldn't feel capable of diagnosing a personality disorder.
I diagnose them all the time, but perhaps incorrectly. But I never never stops me. But what you try and do is get a sense of, are these two people who can sit down with some assistance and actually work out the issues that exist between them. And you get a sense when you talk to your client about what are the problems. Can they agree on some basic kinds of things? Is every issue a battle? You know,
what if
how
they
do you
don't
move
talk at
forward?
all? I mean, it's not, you know, in my line of work, it is not uncommon to see a couple who do not communicate at all. They don't talk. They haven't, even if they've lived under the same roof for some time before they've broken up. It's not uncommon to see couples that just don't talk.
What happens if that pattern continues? You've got children, they're going to separate. Is that pattern of or lack of communication not going to continue?
Well, I think judges try very hard to explain to people that for the sake of their children, they have to move beyond those feelings of anger and resentment, so they can communicate with each other and be co-parents. But and you're only meeting one party. At least I, as a judge, meet them both. But when you start, you're meeting the one that's going to be your client. If they tell you, look, we haven't talked in months, I'm very, you know, that person's angry with me because I found someone else, or vice versa, or whatever the reason is does the door shut?
No, I don't think the door shuts. One of the things you have to remember is that the first thing we do if we have a four-way meeting, and Bob's referred to four-way meetings, that means that husband and wife, or the two partners, and the two lawyers meet together. So there's four of us, called a four-way meeting.
Which means somebody's had to convince the other party to go with a collaborative law, which was going to be my next question. Before you get to the four-way meeting, let's say that you've discussed collaborative law, you've talked a client into to at least trying it. Let's try to work this out as a team without going to court. It's not an option, and we're going to look for creative solutions to resolve all of your issues. Is that parent then expected to speak to the other parent and say, look, I went to a collaborative lawyer, would you like to check that out? Or is there something else they can do that's more helpful?
Well, they can do that if they speak to each other. Or we can write them a letter, write the other side a letter saying, hey, your spouse came to us, he or she would really like to resolve this amicably and without going to court. If you'd like to think or contemplate collaborative law, here's some lawyers who do collaborative law. Or here's our website. You can
and does every town
see.
have a website? Every major center in North America? How would you find the website? Let's say if you live in, I don't know, some mid-range town in North America. Can you Google collaborative law and the name of your town and find a website?
You may not be able to find one in every town. You may be able to find one close by, though, because it certainly is all across Canada and all across the United States.
And Europe.
Yeah, a huge group in England.
Is it fair to say that collaborative law is the newest and most productive new development in family law? Because that's the impression I get.
Well, I'm trying to think of how long ago we did our training, so it doesn't feel all that new. We probably did it 10 years ago, didn't we?
10 years ago, yeah.
But it is a newer kind of way of approaching it, and it's slow to catch on. I mean, not every lawyer can be a collaborative lawyer.
Well, it's funny you should say that. I was wondering in my mind, you know, I deal with litigators who try their best to resolve cases. I mean, I don't think it's fair to say that every lawyer that comes to court is looking to complicate a dispute. For one thing, many people can't afford it, and they may have instructed their lawyer that, you know, I'm not going to keep going to court. I want you to try to resolve it quickly. But it looks to me like more and more lawyers are getting into collaborative law. And I wonder, does it take a special kind of lawyer to do this kind of work? Is there a social work aspect to it that doesn't exist in your litigation practice?
I was going to say, I don't think there's a social work aspect. We leave that to the professionals who do that, the coaches. We're still there just to give our legal advice. We don't become social workers or mental health professionals.
But the layer of training that you get is different than what a traditional lawyer gets, both in law school and if they work at a firm where they don't do collaborative law. There's something different about that seems to resonate with a certain kind of person.
Yes, I think that's true. And because we're looking at it from an interest-based perspective, not a positional interest-based perspective.
What's an interest-based perspective?
Well, when you are trying to look at it from both sides, you're trying to come up with something that works for the family. It's not an individual solution like you might find in court. It's a family solution. And if I can give just one brief example, the founder of the collaborative group in Medicine Hat, her name is Janice Pritchard. And actually, she came out here to give us training in 2002. She was known as one of the most aggressive litigation lawyers
Really?
ever. And she did that internal shift. She saw that she could do something better to help the community. And she became the founder of the group. And she now has taken over charge. She's done more collaborative cases, I believe, than anybody else in Canada. This was an arch litigator.
So what aspect of the personality causes the shift? Is it an awareness that the litigation, as Trudy mentioned, that deep down you know that litigation often makes things worse for people in their relationship with each other after the court case is over, that makes a lawyer think, maybe I could do this differently? Or is it some desire to step out, use a different skill set than what you're using when it's advocacy all the time? In an adversarial setting, I mean.
Because I've also done a lot of litigation, I know how I felt when I left the courtroom. I did not feel happy. I didn't feel good. I was there because I had to be, not because I wanted to be.
Even if you were successful?
Even if I was successful, because
Do you
I
agree
knew
with that, Trudy?
Well, that was just my own feeling. And I knew that if any problem happened subsequently, where would you go back to? You would go back to the court system.
Right.
Whereas in the collaborative process, you go back into the collaborative process. And I
So
think
your job satisfaction really increased when you decided to focus on collaborative law.
Absolutely, and I feel every lawyer has a duty to do what they can to make the community better. And to me, litigation by itself does not achieve that result. The collaborative process brings out to me the best that a lawyer has to offer. And I think a lot of the skill base that we've learned during law school can be supplemented by the kind of holistic training, mediation training, other training to help move the family down that road of positive reconstruction.
How do you think the rest of the legal profession views collaborative law?
I think that there are certainly some people in the profession who see those who have embraced collaborative law as sort of selling out, or the ones who just don't like going to court or aren't any good at it, don't have the stomach for it.
Except that a lot of them, like you, do litigate.
Absolutely. And I think what's important is that we can't paint litigators as all completely bad. Every one of us who litigates is trying to settle a case at every step of the litigation. I can't imagine that there's a litigator out there that isn't trying to settle matters.
I like to think so, certainly as a judge. Well, when we come back, still to come. How much does it cost? How long does it take? Who are these other people that have to come to the table to help people resolve their cases out of court? Stay with us. Welcome back to Family Matters. I'm Justice Harvey Brownstone, and I'm talking today with two collaborative lawyers, Trudy Brown and Bob Klassen. We've been talking about a client coming to see you, deciding that collaborative law is right for them. They are able to communicate with their ex-partner. They are able to, and they're willing to want to resolve things in a non-adversarial way. And the other partner is willing. So you mentioned there's four-way meetings. So they each get themselves a collaborative lawyer, and you're four of you at the table. What happens then?
First thing we do is we look at the collaborative law contract.
There's a contract.
We have to sign a contract to say that we are not going to go to court. I mean, one of the things you have to realize is that the contract binds not only the spouses, but the lawyers. Because it's way too easy for those of us who've been in litigation all these years to get to a tough part of a negotiation and to say, that's it, we're going to court. The contract says we won't do that.
All four of you have to sign the contract.
That's right. Yes.
And if a client later says, I don't like how this is going, I think I can do better in front of a judge, what happens?
Then we as the lawyers back off, and they have to get new lawyers and start all over again.
But what about the other party who still wants to try collaborative law? Does that party lose their lawyer too?
Yes.
So isn't that a bit of a problem? I mean, let's say I'm negotiating in good faith. I'm happy with how it's going. I wish it could go better, but I'm happy that I still want to do it this way. My ex-partner says, I've had enough of this. I'm going to court. This is too touchy-feely for me. I'm out of here. Do I lose my lawyer?
You do, but what we have in our participation agreement, that's what we call it, a collaborative participation agreement. There is a provision that if you do terminate or desire to terminate the process, you cannot do anything for 30 days. It's like a cooling off period. So for 30 days, you can't go and commence an action in court unless it's an emergency, somebody's fleeing the jurisdiction with children. And that gives everybody a chance to kind of think about which way they're going to go. And I have seen that cooling off period enable the person that's not happy with the process rethink where they're going. Now, sometimes they don't like the particular lawyer, so that they can still go and change to another collaborative lawyer. That might be a conflict between the lawyer and the client.
Does this happen very often?
Not very often, does it? It's very rare.
So you sign the contract, you've all agreed, you're going to work together to find a solution without litigation. Then what happens?
Well, one thing might happen, and something might have happened actually before,
yeah.
In that we've sent both of the parties off to their own separate coaches to get ready for these meetings.
A coach?
A coach.
Mental health professional.
You mean like a psychologist?
Psychologist, counselor, clinical counselor, social worker. Because the goal is when you're in these four-way meetings, they're fairly intense, especially when you're sitting across the table from a spouse you don't like very much anymore, and with whom you haven't communicated probably very well for years.
So you've got to have a lawyer, you have a coach who's helping you deal with the emotional baggage in order to be able to negotiate with your ex. Well, what does all this cost?
Well, a lot of people have employment assistance programs. These are all registered professionals, and they usually charge a very reasonable cost. I mean, it's compared to what you pay to lawyers. I mean, lawyers are running, what, $200, $300, $400 an hour.
Including for collaborative law? It's between $200 and $400 an hour, but that's what you'd pay for a lawyer anyway.
Well, that's
in
right.
family law. So you don't charge more or less than any other family lawyer.
No.
And if you don't happen to have a benefit package at work that allows you to get a mental health professional, a coach, you're paying for that person too. Does everybody have to have one?
I tell you what I do. What I do is I take an initial retainer, as they call it, a deposit towards the collaborative process. And as
Am I allowed to ask, like, how much the
usually
typical?
$2,000 is what I usually ask for.
I ask for more.
She asked for more.
Yeah?
Trudy
How
asked
much?
for more. But as part of that retainer...
No, really, I want to get a good idea.
Yeah.
I mean, because litigants tell me in court all the time, when I see them without lawyers, they say, well, I couldn't hire a lawyer. The lawyer wanted usually between $5,000 and $10,000 retainer, and I didn't have it. So I'm trying to figure out, is this in the same range for collaborative law? Between you say
Well, I
$2,000?
can only say what I charge, and I ask for a retainer of $2,000, and as part of that retainer, I pay for the first coach, or the client pays for the first visit to the coach.
Out of that retainer?
Out of that retainer.
And how long do you need a coach? Does it depend on how you're doing?
And some people don't need coaches at all.
Yeah.
I mean, if you have, Bob and I recently did a case where the parties had a joint business. They didn't go to coaches, and we resolved that matter fairly rapidly.
You know what the subtext to what you're saying here is that if you can manage to let go of the anger and the unhappiness and the bitterness that you feel towards your ex, it's a lot cheaper.
Oh, yeah.
If you could manage to do it yourself or through some form of self-help process, or maybe speaking to a counselor on your own, as part of the breakup, as part of the aftermath of the breakup, so that you can face your ex in a very civilized, business-like way, and you don't get emotional about it, you could save a lot of time and money.
Absolutely.
Well, you know, as well as anyone else, that as you get more emotional, there's kind of a corresponding intelligence that goes down. Your ability to solve problems is much lower the more emotional you are.
I think they still remain intelligent, but the emotions do take over.
The ability to solve problems is what goes down. And so if you can handle that emotion, and we're not saying you don't have to be emotional, you just need to channel it in a different way and be able to concentrate in the meeting on the issues that are really on the table.
So you sign the contract. You may or may not need a coach. You may need a coach for a little bit, but not very long. You have these meetings. Tell me about when other people get involved, because you mentioned other experts that may have to come to the table. How does that work?
Well, we have in our group, in Victoria, I can only speak about that, we have 52 members in our group here. There are 37 lawyers, and we have about 5 coaches, we have 4 child specialists, we have about 5 financial advisors, all of whom have had this training. And one of the things that is often at work in these collaborative cases is a fear, maybe by both sides, that their financial security is going to be at risk as they go forward. That's a pretty common feeling.
Sure.
So the financial advisor comes in, but doesn't work just for one, but helps both come up with a financial plan that recognizes what each of their needs are. And so we sometimes have 5-way meetings where we have the 2 lawyers, the 2 clients, and let's say a financial advisor. And when Trudy and I were involved in the case that she just mentioned, we actually had a chartered business valuator who came in, and he was credible, he was neutral, and he helped both parties and came up with a solution that enabled us to sign a separation
To
agreement.
evaluate the value of the business.
Yes.
Now, this is very important for people watching to understand, because what happens in court is that each party would have to hire their own expert to do a report on what the value of the business is, which is double the cost, of course. And then I guess the judge would decide which of those reports is more fair, more accurate, or maybe a third one is needed. So that can be a lot cheaper.
A lot
Isn't that
cheaper.
interesting? Even though you might need to spend money on some experts like a coach, it might in the end be cheaper because you're using one expert. What about if you're having issues, difficulty resolving parenting issues? You can't agree on the parenting plan. Each parent wants the child with them all the time, or almost all the time.
Or they can't agree on certain discipline methods or bedtimes.
Or school.
Any of those things. We have child experts that can come in and are neutral and work with both of the parties.
Work with them together.
Yes.
What's the feedback you're getting from clients that go through this process? Do these agreements stick?
I have been doing it we've been doing these agreements the last 10 years because Trudy and I were together when the group was started. And I can count on my hand maybe the ones that have fallen that needed to be revisited. And if they did need to be revisited, we use the process, the collaborative process, to come back together and see what bumps along the road need to be clarified. Right, Trudy?
That's correct. I mean,
You know
I've
what?
had a couple that have failed.
Yeah,
A
we all have
couple?
ones
And
that
did they go
fail.
to court?
Yes,
But with a different lawyer.
that's
with
right.
a different lawyer?
But very rarely.
That's correct.
Can you tell us what kinds of things make that happen? For example, I'm thinking to myself, you were talking about the financial aspects of it. Implicit in that is that both parties have to be honest with each other about what they've got. Now, it's amazing to me how many people have been in a long-term relationship and don't know anything about the finances of the other party.
That's correct.
Really, it's surprising to me how little one party can really know about what the other party even earns, let alone what property they have. How do you ever really know if the other party's being forthright with you?
Could I just maybe address that? Because when you talked about the first 4-way meeting, one of the things we have on our agenda is financial disclosure. And when we come into that meeting, we usually exchange sworn property and financial statements with relevant additional information. And so we can look at that information and see if more is required. And often that happens at the first 4-way meeting. We need more independent verification. So when you've got 2 lawyers representing 2 clients, usually disclosure is fairly common. I don't recall too many instances where there has not been a disclosure that hasn't been made. And
But
if it
that
has,
makes me wonder. I mean, if someone came to you and said, my ex-partner is self-employed, runs a business, I'm convinced that person works under the table, their income tax documents are not reflective of what they really earn, I think there's more money there. Is that a sign to you that collaborative law isn't going to be the right road to take?
No, because we know that that's actually something that does happen in the real world, and we have to deal with it. And that's one of the places where the lawyer-to-lawyer trust becomes important. So if I have the client who's a contractor, who works under the table so much of the time, I have a duty to sit down with that contractor and say, we have to work out how much money you haven't declared. Now, we're not telling the Canada Revenue Agency, and we're not telling anyone else, but we have a duty to tell the other side and the other lawyer. So if that client's not going to work with me on that basis, I have to withdraw.
Does that happen?
Yes.
It does happen.
It does happen, where you've had to fire the client.
Yes, quite true.
Because you don't think the client's being forthright.
That's right.
I mean, the typical thing we would see in court is a person who claims to be earning a low income, and that's what we see on their income tax. But, for example, when we see their credit card statements, bank statements, lifestyle, what the mortgage payments are, the car payments, it's clear that there's more money at their disposal than what they've declared. That's how a court often sees. Is that what you do too?
That's correct.
Absolutely.
And particularly if your client is suspicious about the other one, we ask for more and more information. Access to all of the bank accounts, access to the credit card statements, going back and tracking forward. We can do all of that kind of stuff within the process to try and convince ourselves and our clients that we have full disclosure.
So this is about two people that are able to make decisions for themselves, able to cooperate with each other and at least communicate with each other on some civil level, able to put away the emotional trauma of the breakup and focus on the issues and on their children, able to be honest. I'm making like a mental checklist in my mind about what you really need. You know, if I were watching this show, what would I need to put on the table as a person, and what would I expect my partner to be able to do? And obviously a lot of people do it because collaborative law is growing.
One of our biggest roles in collaborative law is to be role models for our clients.
But what if you've never broken up with anybody?
Oh, is there anyone out there that hasn't broken up with someone?
No, I don't think so.
You know, but we have the duty to treat the other side with respect, to show that you can in fact disagree, but in a respectful way.
And not be disagreeable.
Exactly right, and that you can actually reach agreements with someone that may not be your best friend.
And most of that happens at the table with 4 people, or maybe 5 or 6, depending on which experts you need to help you, all trying to find the right solution, which may or may not be inside the box of the law. You could be creative and do what works for you. I think that that's a very appealing way to resolve issues, myself as a judge, because I'm not giving it over to a stranger. I've got some opportunity to at least co-steer this with help and not turn it over to a total stranger who may or may not side with my view of the history.
Well, we know that in court situations, quite often both sides are unhappy at the end of the day.
I hope this episode of Family Matters has been informative and interesting for you and will help you make the best, most informed decision about how to resolve your family disputes. From everyone here at Family Matters, thank you for joining us. See you next time.